In the Heller case, the Supreme Court made clear that the Second Amendment protects firearms in common use.
It's important that our Constitution does have a Second Amendment.
I think that all the amendments are important. It's very hard to start comparing.
Process rights as every other American before they lose their constitutional right.
Yes.
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 Doing, if we can't save all lives, it's not worth saving a single life. Well, I suppose that.
In the United States, fentanyl is the #1 killer of Americans in the United States.
I'd also like to address the House on an issue that occurred yesterday in Maine, another assault weapon.
Supreme Court just announced new law on all assault weapon and magazine ban. Judge strikes down California ban. Let's dive into some legal fireworks in the world of guns, shall we? So picture this. Judge Bonnet, or Saint Bonnet as they call him in California, just dropped a legal shocker. He basically took a sledgehammer to the California attack weapon ban and said, "You're unconstitutional." Now, if you're a gun owner in California, this is like winning the jackpot at the gun enthusiast's casino. Because let's face it, California isn't exactly known for its relaxed stance on firearms. Their gun control measures are about as strict as your grandma's old-school parenting. So what's the deal with this ruling? Well, Judge Bonnet, with his mighty gavel, made the bold move of declaring the California attack weapon ban unconstitutional. This is a pretty big deal. It's like saying, hey, you can't tell people they can't have certain types of guns because, well, it's against the rules. The implications of this are enormous. It's not just about being able to keep those so-called attack weapons, it's about challenging the whole idea that the government can dictate what kind of firearms you can and cannot own. It's like a big legal pushback on those who think the Second Amendment needs a little modern-day reinterpretation. And for gun owners in California, it's a breath of fresh air. It's like being told, hey, you can keep that AR-15 without worrying about breaking the law. It's a win for those who believe in their right to bear arms as the good old Second Amendment intended.
Clear as possible, and that's their beef. The Second Amendment says the right to keep and bear arms shall not be infringed.
In voting on whether this nation is going to be all in on a new nuclear arms race, or whether we're going to...
It's important that our Constitution does have a Second Amendment.
I think that all the amendments are important. It's very hard to start comparing.
Bans for 18 to 20-year-old adults, guns that are in common use. It bans...
to be stopped. Now, at the same time, this committee, the Senate Committee, Senate Veterans Affairs Committee have been...
But hold your horses, cowboys and cowgirls, because this fight is far from over. The state of California is not about to back down without a fight. They're like the kid who refuses to share their toys. They filed for stays left and right, hoping to keep that ban intact. It's like a legal thug of war, and the rope stretched pretty tight. So while this is a big victory, it's only one round in a long bout. The battle's not just happening in the courtroom, it's happening in the court of public opinion too. Gun rights advocates are cheering, while those who support stricter gun control are shaking their heads. In a way, it's like a showdown in the Wild West of legal battles. Saint Bonnet has fired the first shot, and the echo of his ruling is reverberating throughout the state. But stay tuned, because this fight is far from over. It's a legal showdown that's bound to keep us all on the edge of our seats, wondering what'll happen next in this epic gun rights saga. Ninth Circuit's role. Let's take a closer look at what's happening in the wild world of the Ninth Circuit Court and its role in the whole attack weapon ban saga. So first things first, the Ninth Circuit Court is like the arena for this legal gladiator showdown. It's where the whole attack weapon ban challenge is playing out. Picture it as the Thunderdome of the legal world, where the fate of California's gun laws hangs in the balance. Now here's where things get interesting. There's this thing called an emergency motion that's currently hogging the spotlight in front of the Ninth Circuit's Emergency Motions panel. Sounds pretty dramatic, right? Well, it is. This emergency motion is like a legal Hail Mary pass. It's like the state of California saying, hold on a minute, Judge Bonnet, we need to put things on pause. What they're asking for is an extension of the stay on Judge Bonnet's decision. The stay, you see, is like a temporary hold that prevents his ruling from immediately going into effect. Think of it as a legal equivalent of a timeout. The Emergency Motions Panel is the group of judges in the Ninth Circuit responsible for making the call on whether or not to grant that extension.
Funding the destruction, the potential destruction of all that exists on this planet.
doing? If we can't save all lives, it's not worth saving a single life. Well, I suppose that...
They're in jail. They can't be in communities shooting people. Do you agree with that statement?
We work very closely with D.C. police.
Process rights as every other American before they lose their constitutional rights.
Yes.
Yes.
Liberty, law-abiding citizens in this country enjoy. And they're coming for your firearms.
It's like the referee in this legal boxing match deciding who gets to throw the next punch. Now, the decision is no small factor. If they say yes to extending the stay, it means Judge Bonnett's ruling doesn't take effect just yet, and the attack weapon ban remains in place. If they say no, it's like giving the green light for his ruling to be the new sheriff in town, and California's gun laws get a makeover. The clock is ticking, and there's a real sense of urgency here. It's like a legal thriller, and the outcome could impact the lives of gun owners in California for years to come. So as we sit back and watch this legal drama unfold before our very eyes, we're left wondering what the Emergency Motions panel will decide. Will they extend the stay, or will they let Judge Bonnett's ruling stand? It's a cliffhanger, and all eyes are on the 9th Circuit as they hold the fate of the attack weapon ban in their hands. Stay tuned, folks, because this legal roller coaster is far from over.
Was made to count human beings as 2/3 of one person if they had more melanin.
And their recent actions against firearms manufacturers, federal firearms licenses or FFLs.
When it is fired. So it just doesn't make a whole lot of sense, and I'm sure Mr. Bosco.
The Miller case. First off, the Miller case is like the heavyweight champion in the ring, ready to slug it out with California's gun laws. It's essentially a legal challenge to the state's attack weapon ban, which is about as controversial as a political argument at Thanksgiving dinner. Now here's where it gets interesting. The Miller case wasn't exactly moving at the speed of light. Nope, it was on hold in the 9th Circuit, and there's a good reason for that. You see, the 9th Circuit had a backlog of cases. It's like a traffic jam on the legal highway. All of these cases were piling up, and the Miller case had to wait its turn. But that's not all. There was another major player on the scene, the pending Supreme Court decision in the New York State Rifle and Pistol Association v. Bruin case. That case was like the big elephant in the room, and the 9th Circuit didn't want to make any hasty moves until the big guy in Washington had his way. So while the Miller case was waiting in the wings, the legal world was watching what the Supreme Court would decide in the Bruin case. It was like waiting for the results of a high-stakes poker game. Everyone wanted to see if the Supreme Court would set a precedent that would impact the Miller case. But here's the kicker. The Miller case never made it to the full 9th Circuit 3-judge panel for a proper hearing on the merits of the appeal. Nope, it was in this sort of legal limbo. The only review that it got in the 9th Circuit was before a 3-judge panel, and they were trying to decide whether to send the case back down to Judge Bonnet after the Bruin decision, or whether to move forward with an actual merits decision. It's like the legal equivalent of a quarterback faking a pass, but then deciding to run with the ball. They couldn't make up their minds on what to do with the case. So that's where the Miller case stood, on hold, waiting for its moment in the spotlight while legal battles raged on around it. It's like a character in a long-running TV series waiting for their spin-off show to finally air. But hold on to your hats, guys, because the Miller case might just be getting its time to shine soon, and we'll be right here to see how it all plays out in the courtroom. 2 types of stays. Let's break down what's happening on California's side of the ring in this legal brawl over the attack weapon ban. The state is pulling out all the stops to keep the ban in place, and they're doing it by requesting not 1, but 2 types of stays. First up, we've got the emergency motion for a state pending appeal. This is like California's way of saying, whoa, hold your horses, Judge Bonnet. We can't let your ruling go into action just yet. They want a temporary halt on the whole shebang while they work on their appeal. It's like a legal pause button, and it's meant to keep things the way they are until they sort out this mess in the court. But wait, there's more. California isn't stopping at just 1 stay. They're also throwing in an administrative stay into the mix. This one's like a backup plan in case the emergency motion doesn't quite do the trick. It's a temporary hold on the ruling, similar to the emergency motion, but it's like the legal equivalent of checking your seatbelt on a bumpy ride, just in case. So what's the deal with these stays? Well, they're all about maintaining the status quo. It's like a way of saying, hey, let's not change anything until we figure out where this whole legal showdown is headed. They're like the safety nets of the legal world, making sure nobody falls through the cracks while the case works its way through the courts. And that's where the drama unfolds. Will California manage to convince the courts to grant these stays and keep the attack weapon ban in place? Or will the other side prevail and Judge Bonnet's ruling becomes the new sheriff in town? It's a nail-biter, and we're all just waiting to see how this legal roller coaster ride ends. Stay tuned, folks, because we're not done just yet. Ninth Circuit's unique en banc panel. Hold on to your seats, guys, because the Ninth Circuit is where things get a little, well, unique. When it comes to handling emergency motions, this circuit's got a one-of-a-kind setup. So what's the deal with this emergency motion panel, you ask? Well, it's like a mini judicial task force, and it's responsible for making quick decisions on urgent matters. But here's the kicker. It's not made up of the same judges all the time. Nope, these judges rotate like a revolving door. You see, in the Ninth Circuit, they like to keep things fresh, so they randomly select 10 judges to serve on this panel for a month. These judges are like the Avengers of the judicial world, coming together to tackle emergency motions that need swift action. They're the ones who decide whether to grant a stay or to keep the legal ball rolling. But wait, there's more to the story. The Ninth Circuit's emergency motion panel has one more trick up its sleeve.
I'd also like to address the House on an issue that occurred yesterday in Maine. Another assault weapon.
You haven't been charged with the crime, but they can take your firearm. They can take your property. They can take away your second.
Being wounded. It's time for this House to act on extending
the Second Amendment protects firearms in common use at the time. During the markup,
you see, the Chief Judge of the Ninth Circuit is like the honorary 11th member of this panel. They bring the wisdom and the experience of a Chief Judge to the table. Now here's the twist. The specific judges on this panel change every month. It's like a game of legal musical chairs. You never know who's going to be in the hot seat making decisions that can have a big impact on the cases before them. This setup is quite different from the other circuits where you might have a dedicated panel of judges handling emergency motions. In the Ninth Circuit, it's like a lucky draw, and that randomness can keep things interesting. So when it comes to emergency motions, the Ninth Circuit likes to keep us all on our toes. The judges change, the Chief Judge adds their expertise, and every month it's like a new cast of characters making decisions that shape the legal landscape. And with the Miller case and the attack weapon ban challenge in the mix, you can bet that the Ninth Circuit's unique structure is about to face its own kind of trial by fire. Stay tuned, because this legal roller coaster is far from over, and you never know who'll be calling the shots next month.
Not liking a law isn't a reason for ATF not to.
Well, Mr. Wilcox, there's no law. Congress didn't pass it.
Medicine was the first school of medicine in the United States to allow students with DACA status.
In the United States, fentanyl is the #1 killer of Americans in the United States.
Future outcomes for the Miller case. Now let's put on our legal detective hats and dive into some speculation about the future of the Miller case. We're in for a legal thriller, and here's what the crystal ball is whispering to us. First up, the emergency motion panel. It's like the starting gate in this legal race. and the odds are looking good for an administrative stay. What's an administrative stay, you ask? Well, think of it as a temporary pit stop in this legal marathon. We're talking about a 10 to 14 day pause button just to give everyone some breathing room. It's like a timeout in a heated basketball game where the players catch their breath and plan their next move. But that's just the beginning. The real action is with the 3-judge panel assigned to the Miller case. They're like the referees who like to make the big calls, and here's where things get interesting. Speculation is rife that this panel is going to grant a permanent stay. What does that mean? Well, it's like saying, hey, we're hitting the brakes on Judge Bonnet's ruling for a while. This stay will last until the appeal process runs its course. Why the optimism for a permanent stay, you ask? Well, there's a sliver of hope in the mix. You see, the Ninth Circuit's composition has shifted a bit, and now it's closer to a 50-50 split between judges who lean pro-gun rights and those who lean the other way. So there's a chance that the panel might lean in favor of a more permanent stay. It's like hoping your favorite team's star player is on the field when the game is on the line. Of course, Nothing is set in stone in the world of law, and there are no guarantees. But these speculations paint a picture of a legal battle that's far from over. It's like a chess match where every move matters and it's anyone's game. So we'll keep our eyes on the horizon, waiting to see how the emergency motion panel and the 3-judge panel play their cards. The Miller case is like a poker game with high stakes, and it's not over until the final hand is dealt. Stay tuned, because this legal saga is bound to keep us all on the edge of our seats.
This is a lever action. Under this bill, lever actions apparently are okay.
The previous ban on assault weapons. This has nothing to do with the Second Amendment.
The Second Amendment says the right to keep and bear arms shall not be infringed.
Other key cases. Hold on to your legal hats, guys, because the Miller case isn't the only game in town when it comes to challenging attack weapon bans. Let's talk about another heavyweight contender, the Beon v. Maryland case. So what's the scoop with Beon v. Maryland? Well, it's a legal challenge to Maryland's own attack weapon ban, and it's creating some serious ripples in the world of gun rights. Picture this. Maryland, like California, has some pretty strict laws when it comes to what they consider attack weapons, and just like in the Miller case, folks in Maryland decided they've had enough and took their case to the court. Now, what makes this case particularly interesting is its journey. You see, after the Supreme Court made its decision in the New York State Rifle and Pistol Association v. Bruin case, things started to get real interesting for cases like Beon. The Supreme Court's ruling in Bruin set some new parameters and had folks reevaluating their legal strategies. And here's the twist. The Beon case didn't just keep on trucking in the Fourth Circuit. Nope, it was sent back to the Fourth Circuit after the Bruin decision, and that's where the real action is happening. It's like the legal pendulum is swinging back and forth, and we're all watching to see where it lands. So what does this all mean? Well, it means the legal battles over attack weapon bans are far from over. There's a whole batch of cases out there, and each one has its own unique story and unique strategy. It's like a legal chessboard with moves and counter moves, and it's not just one game, it's a whole series of matches. The Beon case is just one more piece of the puzzle, and it's a reminder that this legal saga isn't limited to one state or one court. It's a nationwide tug of war over gun rights, and the outcome in one case can have a domino effect on the rest. So keep your eyes peeled, because the legal landscape is constantly shifting, and these cases are like plot twists in a gripping legal drama. The battle over attack weapon bans is far from over, and the Beon case is just one chapter in this ongoing story.
3-round burst or semi-automatic. Those firearms are not allowed for purchase in the United States today.
I'd also like to address the House on an issue that occurred yesterday in Maine. Another assault weapon.
For years, the Democrats told us we're not coming for your guns. Oh, yes, they are.
The role of the Supreme Court. The Supreme Court is like the ultimate referee in the world of gun rights cases, and its decisions can have a seismic impact on the legal landscape. First off, let's get this straight. When the Supreme Court makes a ruling, it's like the final word in the game of legal chess. Its decisions set the tone and provide the legal framework for all the other cases that follow. In the case of Miller, the Supreme Court is like the wizard behind the curtain, and its influence is profound. Now let's talk about the New York State Rifle and Pistol Association v. Bruin case. This one's a big deal, and it's all about concealed carry permits. The Supreme Court had this case on its plate, and everyone was eagerly awaiting its decision. It's like the whole nation was sitting on the edge of its seat, waiting for the big reveal. But here's the twist. The delay in the proceedings of other cases, like Miller, was heavily influenced by the pending Bruin decision. It's like a traffic jam on the legal highway. The Supreme Court was taking its time, considering its options, and all these other cases were put on hold, waiting for the big domino to fall. Why does the Supreme Court's role matter so much? Well, it's because their rulings can shape the destiny of gun rights across the nation. When they make a decision, it can become the legal yardstick that all other cases are measured against. So the Supreme Court is like the conductor of the legal orchestra, setting the tempo and the mood of the music. Their role in gun rights cases is pivotal, and the decisions they make can send ripples throughout the legal world, affecting cases like Miller's as well as many others. That's why we all keep our eyes on the Supreme Court. Their rulings can be game changers, and the outcome of cases like Miller isn't just determined in the lower court. it's also profoundly affected by the judgments handed down from the highest court in the land. So in the epic saga of gun rights cases, the Supreme Court is the ultimate hero or villain depending on which side of the legal battlefield you're on. Their influence is far-reaching, and their role in shaping the outcome of cases like Miller is nothing short of pivotal.
They should be respected.
Reclaiming my time, so Mr. Chairman, I'd like 40 seconds
I've seen
back on
my
the clock.
constituents die in battle.
Piece of legislation and voting on whether this nation is going to be all in on a new nuclear arms race.
There's a hearing that you can't be at, your counsel can't be present, you haven't been charged with the crime.
Advocating for Second Amendment rights. Let's talk about a group of unsung heroes in the battle for Second Amendment rights, the advocates. These are the folks and organizations who roll up their sleeves and fight tirelessly to protect our right to bear arms. They're the real champions in this ongoing saga. First off, advocacy groups are like the drum majors in a parade for gun rights. They rally like-minded individuals, pool resources, and amplify the collective voice of gun owners. These organizations, like the NRA, GOA, and others, are the powerhouses that drive the legal battles and push for legislative changes. They're like the legal warriors who gear up for battle, armed not with weapons, but with facts, data, and persuasive arguments. But it's not just about the big players. Individual gun owners are the heart and soul of the Second Amendment movement. They're the everyday folks who write to their lawmakers, attend rallies, and in many cases take legal action to challenge restrictive gun laws. They're the real-life heroes standing up for their rights and refusing to back down. Now here's where it gets interesting. Public opinion and advocacy efforts go hand in hand. The court of public opinion is like the wind that fills the sails of the gun rights movement. When the majority of the people support these rights, it sends a powerful message to lawmakers and the courts. And let's not forget legal action. It's like the artillery in this battle. Advocates and advocacy groups often file lawsuits to challenge gun control measures they believe infringe upon Second Amendment rights. These legal battles can influence the direction of gun rights cases and push the conversation forward. So the fight for Second Amendment rights is like a symphony of efforts. Advocacy groups, individuals, public opinion, and legal action all play their part in this ongoing battle. They're the forces that keep the conversation alive and push for a balance between gun rights and public safety. In the end, it's not just about the legal battles, it's about advocating for a cause that's deeply ingrained in the fabric of American society. So here's to the advocates who keep the fire burning and ensure that the Second Amendment remains a vital part of our nation's history and future.
To a member on the Democratic side that served in the combat area designated zone and deployment of our country.
And they're coming for your firearms. 6 weeks ago, it was the red flag law.
The ongoing battle over attack weapons. Ladies and gentlemen, we've reached the edge of our seats in this ongoing battle over attack weapons, and the fate of the Miller case is hanging in the balance. It's like a high-stakes poker game, and all eyes are on the Ninth Circuit as the clock is ticking toward a crucial decision deadline. You see, the Ninth Circuit is under some serious pressure. The emergency motion panel is facing a decision that could change the course of the Miller case. Will they grant the administrative stay, giving California some extra breathing room? Or will they refuse, allowing Judge Bonnet's ruling to go into effect? The outcome of this decision isn't just about a single case. It's like a pebble in a pond, creating ripples that can be felt far and wide. Gun owners across California are watching with bated breath as this ruling could have profound implications for their rights and freedoms. But it doesn't stop there. This legal battle isn't just about one state. It's contributing to the broader national debate over the legality of attack weapon bans. It's like a piece of the puzzle in the larger picture of gun rights in the United States. The Miller case could set a precedent that other states and circuits look to when dealing with similar challenges. So as the Ninth Circuit grapples with this decision, the nation is watching and the stakes are high. The outcome could shape the conversation around attack weapon bans, gun rights, and the balance between public safety and the individual freedoms. It's a cliffhanger, a nail-biter, and a legal drama with real-world consequences. Stay tuned, because the final act of this battle over attack weapons is on the horizon, and the nation is watching with keen interest.
The most popular handgun in the United States that was purchased is the Glock 19.
In the Heller case, the Supreme Court made clear that the Second Amendment protects firearms in common use.
Well, guys, that does it for this video. See you next time, and bye for now.